Death penalty or capital punishment, the highest punishment in India. So today we are discussing whether this punishment is really needed one for the smooth functioning of the criminal justice system of India. So what is death penalty? It is the practice of taking someone's life as a punishment for a specific crime by the state. The latest study shows that 108 countries abolished this practice of death penalty, and 55 countries still have this punishment in their penal statutes, including India. Venezuela, the first country, permanently abolished this practice in 1863. The latest was on 20th September 2022 by Equatorial Guinea. And today, as we know, many legal scholars in India argued that this practice is really immoral one and has to be abolished as soon as possible. And also they argued that the ultimate aim of criminal justice system in India is to reform a criminal, not to removing them from the society. And while we looking into the constitution, the Supreme Court held the death sentence is constitutionally valid if it is done through procedure established by the law and not in public interest. The first time in 1973, the validity of death sentence is challenged in the case of Jagmohan Singh. It was challenged on the basis of Article 19 and 21 because it does not provide the procedure. The five judges bench of Supreme Court held that the choice of awarding death penalty accordance with the procedure established by the law. So in 1979, death sentence was held unconstitutional in the case of Rajendra Prasad, where Justice Krishna Iyer held that the capital punishment would not justify it unless it was shown that giving discretion to judge to make a choice between death sentence and life imprisonment on special reason under section 35 of the code would be violation of Article 14 of the Constitution of India. And Krishna Iyer also pleaded for the abolition of capital punishment and retain it only for punishing white collar criminals. In 1980, Supreme Court restored the validity of capital punishment. In Bachan Singh case, as all we know, the Bachan Singh case, it was held that Indian Penal Code section 302 is not violative of Article 21 of Constitution because Article 21 recognizes the right of a state to deprive a person of his life and liberty in accordance with fair, just and reasonable procedure established by the law. Again, in 1992, in the case of Shashi Nair case, the constitutional validity of capital punishment was again challenged, and capital punishment does not serve any social purpose, and court rejected this argument, and now it is well established the capital punishment was constitutionally valid. So Article 134 in Constitution of India says about this capital punishment, and Article 72, as we know, which give the President of India for giving pardon. So Constitution of India give validity the practice of capital punishment. While we are reading the articles in the Constitution of India, we can surely say that this practice is really a valid one in the light of judgments by the Honorable Supreme Court. Bachan Singh, I already told you that the Bachan Singh versus State of Punjab, which gives the court gives a statement: a real and abiding concern for the dignity of human life postulate resistance to taking a life through law's instrumentality. That ought not to be done save in the rarest of rare cases when the alternative option is unquestionably foreclosed. This case was a phenomenal one, and in which the famous statement was given: the capital punishment should be given in rarest of rare cases. And Law Commission has already told you that the Law Commission report in 2015, which also suggests to abolish this practice. It suggested that the death penalty should be abolished for all crimes except terrorism. So whether this punishment should be abolished, that was the question before us. The main argument of death penalty supporters is that it reduces the crime rate in the country. Even today, the crime does not decline. Death penalty does not have a deterrent effect. Really, it is a barbaric punishment. In my opinion, life in prison would be better option. The death penalty cannot be done fairly. Most of the studies conducted all over the world reached the conclusion that maintenance capital punishment does not reduce the rate of heinous crimes. Abolition of death penalty will have added benefit, ensuring that the state killing of its citizens will no longer have any legitimacy and stigmatize extrajudicial executions. Countries abolished this practice, rarely reintroduced it. Philippines abolished this practice in 1987 but reintroduced it in 1993, but it abolished again in 2006, which means that abolishing of capital punishment would not increase of the crime rate. India cannot abolish it without the support of public opinion and legislative backing. The ultimate aim of the death sentence is to deter others. We have no empirical report suggesting this view. Though India signed many international instruments on human rights, still death sentence is on the Statute of India. The main reason is the public support for the capital punishment. They are screaming for the capital punishment in social media whenever any heinous crime happened in India. Still, our people are not aware of the practical difficulties in imposing capital punishment. This punishment does not serve any social purpose. It does not serve the end of justice. In my opinion, the ultimate aim of criminal justice system should be reformation and not to removing the criminal from the society. Human factor is the key factor in the process of delivering justice. So it is not to maintain a fair trial always. It is not easy to eliminate the subjectivity in the process of delivering justice. So giving a long-term imprisonment is a good alternative to the capital punishment. It will reform the offender and release them with strict conditions. Release only when the authorities satisfied that they are no longer a threat to the society. The importance should be given to the reformation if any possibility of reformation exists among the offenders. We have to ensure that the reformed offender got a chance to live the life with the society. Death penalty is not a better option to the life imprisonment. It is necessary to limit death penalty in terrorism, where the offender are not ready to live a peaceful life in the society, even if they got a chance to reform. It is need of the hour, not because of the moral grounds, but in the inconsistencies in the crime investigation. I hope India will join with the nations who already abolished this practice and take progressive step in the criminal justice system. Also, Project on Death Penalty, which was conducted by NALSA in 2014, which always suggested that most of the persons serving death sentence in India are from economically vulnerable sections and backward community and backward religious minority groups. So they also suggested to abolish this practice. And I am concluding this topic that law is needed only when the majority of people in society is good and passive, but minorities devilish and active. Law is needed only in this situation, and as a safeguards the interest of majority, leaves the job of handling the minority to the law. Thank you.